Nancy?
Yes.
All right, thank you very much. We are back on the record now for 28th Circuit Court. By the way, even though our Zoom and YouTube here is just for allowing people access to the courtroom to make it convenient and also to demonstrate transparency. I give a polite little shout out to the students from Basic High School, with whom I had the absolute privilege to speak with yesterday. Thank you. Our next case here again is People in the State of Michigan versus Marcus O'Rourke. File number, once again, is 25-14176FH. Appearances, please.
Please call for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Schwab O'Rourke, who's next to me.
All right, thank you very much. We are here today for a final pretrial conference. This is one of the few cases set for trial in the next coming trial here in Westford County. And the parties have provided to me a written signed pretrial agreement and advice of rights. It appears that the defendant is going to enter a plea of guilt, no contest. Is that right? Why is he entering a no contest, or is it guilty to possession of ecstasy?
Yes, it's guilty
Right.
for the possession of ecstasy.
So he's pleading guilty to count one, possession of MDMC, ecstasy. He's going to plead no contest to a breaking and entering with illegal entry where there's a domestic relationship. And in exchange for that plea, the prosecutor agrees to dismiss the count 2, assault, resist, instruct a police officer, and the 3rd habitual felony offender enhancement. And also there is a sentence agreement that, as a Killebrew, that the court would sentence the defendant concurrently with a sentence in Genesee County that is intended to be entered apparently or issued in that county on March 23rd. Is that correct?
Yes, Your Honor.
Mr. Harrison?
That is correct.
Thank you. Do I have a police report for the no contest portion? Ms. Dahl is getting that, and you go ahead and have it marked, Ms. Dahl. Mr. O'Rourke, is that how you wish to resolve today's file?
Yes.
To the best that you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
You may lower your hand. All right, Mr. O'Rourke, looking back on November 28th of 2025, were you on probation or bond at that time?
Yes.
Where were you on probation or, I mixed it up. Were you on probation or parole?
No.
Were you on bond pending a felony charge from another county?
Yes, it is.
Okay, and is that the case in Genesee County?
Yes, it is.
And what were the felonies there?
Felony firearm, intent to deliver, and ordering publishing.
Okay, so the key reason for asking that question also goes to part of the pretrial agreement. The court has, within its discretion, the right to sentence a defendant consecutively, meaning whatever sentence is given in Genesee County, you'd have to serve that first and then serve this one after that. Do you understand?
Yes, I do.
Now that is discretionary. There are a few offenses which is mandatory. And from what I understand here, based upon what the parties are doing, it is not a case in which it's mandatory, because this is possession of ecstasy. It is not mandatory. And so therefore, there's a Killebrew agreement. We're going to talk about that in just a moment. You are currently charged with 3 counts on a felony information. Count 1 is a charge of possession of ecstasy, also known as MDMA. That is a felony punishable by up to 10 years and or up to $15,000. Plus, there's a 3rd habitual felony offender that could, within the discretion of the court, increase the potential maximum sentence from up to 10 years to up to 20 years. However, if you plead guilty to that count 1, and I accept that plea, the prosecutor agrees to dismiss the request to sentence you as a 3rd habitual felony offender. Count 2 is a charge of assault, resist, or obstruct a police officer. That's a felony punishable by up to 2 years and or up to $2,000. Plus, with application of that third habitual felony offender, the maximum punishment could be increased from up to 2 years to up to 4. However, count 2 and its enhancement will also be dismissed. Count 3 is a charge of breaking and entering, also called illegal entry without an owner's permission, where there is a domestic relationship. And that is a misdemeanor punishable by up to 90 days and or up to $500. And that one, I'm told you're going to enter a plea of no contest. The court can accept a no contest plea in some circumstances, such as potential civil liability and so forth. Is that the reason here today, Mr. Harrison?
Indeed, as well as some issues with memory, but that's not the primary driving force, is the civil liability.
Ms. Dahl, any objection?
No, Your Honor.
Thank you. A no contest plea has the same impact as a guilty plea. The only difference is instead of requiring you to recite the factual basis to support the taking of the plea, I'm going to look at something else, such as a police report. Now, whatever is in that police report, you do not get to later, if it's admitted, later come on and say, well, at sentencing, judge, I don't really agree with it. That one line or that one paragraph is all not true. If you're going to enter a no contest plea, whatever's in there, I'm going to interpret, and for this record will always be considered true. You understand?
Yes, I do.
All right. Now, if I enter, and by the way, I see here I have this written pretrial agreement. I'm going to hold it up. Down here, it appears to have your signature. Is that your signature?
Yes, it is.
All right. So did you talk to Mr. Harrison about all this before you signed it?
Yes, I did.
All right. Also, if you enter a plea of guilty and or no contest, the 2 counts that I discussed earlier, you're not going to have a trial. Does that make sense?
Yep.
Now I'm holding up another piece of paper called an advice of rights. At the bottom, that appears to have your signature. Is that your signature?
Yep.
Read through these rights before signing?
Yes, I have.
And did you understand the words that you read?
Yes.
And once again, you understand even more importantly that if you plead guilty and or no contest, you will be forever waiving these rights as they apply to this particular case.
Yes.
You also will be given up the right to claim that the plea was a result of some promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, inducements we haven't talked about yet?
No.
You mentioned the plea of your own free choice.
Yes.
Mr. Harrison has probably talked to you about potential sentencing guidelines. Is that correct?
Yes.
Has he made any promises to you as to exactly what the sentence would be? Any discussion about the sentencing guidelines? First, I'll tell you, would just be an estimate because we don't know what they're going to score. And the sentencing guidelines are not mandatory. They are only a helpful tool that the court must use, but I do not need to follow it. You understand?
Yes.
Now, we have that written pretrial agreement. We've gone over that. Are you satisfied with Mr. Harrison's representation, availability, and answering all your questions?
Yes.
And you believe entering this plea is in your best interest?
Yes.
Now, I've just remembered that I need to go over the Killebrew agreement. A Killebrew agreement is an agreement that a defendant makes with the prosecutor. I am not a part of that agreement yet. If I don't go along with it and at the sentencing don't comply, then you have the right to withdraw your plea. In this particular instance, that Killebrew agreement is a promise that I will sentence you concurrently, which means whatever sentence you get in Genesee County would be run at the same time this sentence does. So in other words, every night or day you spend there in the jail or prison or whatever is a day that applies to each case. Do you understand?
Yes.
Do you have any questions about that?
No.
You wish to enter the plea as we discussed.
Yes.
So keep in mind that the plea to count 3, I anticipate to be a no contest. I only advise you of that because every time I do this, if I don't remind people, they forget and say guilty. As to count 1, possession of the controlled substance ecstasy, how do you plead on that one?
Guilty.
And as to count 3, the breaking and entering or unlawful illegal entry, How do you plead to that one? I have before me what is marked now as People's Exhibit number 1. It is a City of Cadillac Police Department report, incident number 25-3424. Ms. Dahl, are the people asking the court to accept that exhibit to support the taking of the plea for count 3?
Yes, Your Honor.
And you believe that the interests of justice do not require the defendant to recite a factual basis for that count?
Yes, Your Honor.
Mr. Harrison, does the defense agree to those two as well?
Absolutely.
Count agrees, the court agrees that the interests of justice do not require the recitation of a factual basis. People's Exhibit number 1 is hereby admitted. I'll highlight here that the date range and jurisdictions are well detailed inside this report. One moment. All right, Mr. O'Rourke, now I'm going to turn your attention to the first count. Turning your attention to November 28th of 2025 here in the City of Cadillac in Wexford County. It looks like law enforcement officers were called to a residence, and that residence was on Pearl Street. Is that correct?
Yes.
Looks like it's one of the apartments out there. Is that correct?
Yes.
And when the law enforcement officers were out there, they did a search of your person and found a small plastic bag with a crystallized substance inside. Is that correct?
Yes.
And where was that found?
On my right side, change pocket.
Okay, and you knew that that item was there,
Yes.
and the item contained methamphetamine. Is that correct? I'm sorry, MDMA.
Yes.
And did you know it was there?
Yes.
And did you have in your mind any lawful reason to possess it?
No.
Ms. Dahl, do you believe you provided a factual basis as to count 1?
Yes, Your Honor.
Do you believe that the reports for People's Exhibit 1 satisfies the proof required for count 3?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court is in compliance with Michigan 6.302?
Yes, Your Honor.
Mr. Harrison, do you agree with all those responses as well?
I do indeed.
The court agrees and finds the defendant's pleas are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof for count 1. The court finds specifically that the facts contained inside People's Exhibit number 1 also satisfy the elements for count 3. Therefore, the defendant is found guilty of count 1 and count 3. Sentencing will be set in this matter, and at that time, the other counts and enhancements will be dismissed. Mr. O'Rourke, the case will now be set for sentencing. We do sentencing in this court every Monday morning. I can predict that yours will most likely be in about 4 weeks from this coming Monday. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. That report will describe the pretrial agreement, how you've done on bond, facts about the case, information about your prior criminal history, maybe statements from the victim and for count 3. It will also tell me about how you've done a bond, probation, parole in the past. It will also include a recommendation as a sentence. That recommendation is strictly that, it's just a recommendation. It'll also include a score in the Michigan sentencing guidelines. Again, please keep in mind that it is all recommendations and none of that's mandatory upon the court. There are 3 steps that involve you. Number 1, you're going to get a packet that has already been handed to the bailiff, and you'll get that when you go back to the jail. You're going to complete the contents of that packet and turn it in. You'll also then be subject to an interview with an agent from that office, and you have the right to have your counsel present during that interview. And third, your counsel will meet with you prior to coming back to court after he receives that report and go over it with you. Each side has the right to come back to this report, make objections, or request corrections to the contents of that report. The court revokes bond, remands them into custody, which probably academic anyways because of the case in Genesee County. Anything further, Ms. Dahl?
No, Your Honor.
Anything further, Mr. Harrison?
I have nothing further for the court. Thank you.
Mr. O'Rourke, do you have any questions for me about what we're doing and what's going on today?
Nope.
All right, good enough. Thank you for your time. We are adjourned.